facility of the court since his arrival. If he can please tell us these details.
Thank you. Can I...
Oui, maître. Oui.
The presiding judge. Yes, counsel.
Please. 2 days ago, the whole world has witnessed the degrading fashion in which a former president of a sovereign country was bundled into a private aircraft and summarily transported to The Hague. To us lawyers, this would be called an extrajudicial rendition. To the less legally inclined, it was a pure and simple kidnapping. My client was denied all access to the legal recourse in the country of his citizenship, and this all in the nature of political score settling. Two troubled entities struck an unlikely alliance, an incumbent president who wished to neutralize and choke the legacy of my client and his daughter on the other hand, and a troubled legal institution subject to delegitimization and desperate for a price cuts and a legal show today on the other hand. With this in mind, it is not surprising that my client was abducted from his country. ICC private jets do not drop out of the thin air. That jet which received my client was coordinated in advance. The UAE is not a state party to the ICC and has no obligation to cooperate with the court. Yet my client sat in transit in that country for more than 5 hours. I invite the registry's representative to present today in court to explain to the judges exactly how they believe this transfer was anything other than a gross abuse of process. Given the precipitous arrival of my client, an elderly man with debilitating medical issues, hard of hearing and poor of sight, he was taken to a hospital for observation. Only this morning have I met him for the first time with less than an hour to discuss legal issues. I have not been able to present him with a hard copy of the arrest warrant because we were not supplied with such. I have not even been able to explain to him what the prosecution requested when seeking the issuance of the arrest warrant. This is because the chamber only established a redacted version of the prosecution request last night. Other than to identify himself, my client is not able to contribute anything to this hearing. Most importantly, he is not able even to tell you that he has been informed of the charges as contained in the arrest warrant for a reason more pertinent to which I alluded in my written request to this honorable pretrial chamber this morning, and which is confidential in nature. Accordingly, I repeat my respectful request, which was rejected this morning, to postpone the substantive aspect of this hearing to the next week, when I will have the opportunity to sit with my client and to explain to him what a confirmation hearing is and what the disclosure is and how the prosecution alleges that he committed crimes. I thank the court for its attention and regret to say that I do not have instructions to continue my submission any further today. Thank you.
Thank you, counsel. Now, with regard to the health issues of Mr. Duterte, I believe that the court has taken specific measures with regard to his health situation, and I note that subsequent to his arrest and when he arrived at the detention centre, the court's doctor was of the opinion that you were fully mentally aware and fit, and that you have undergone further checks and tests at the detention facility. And when you broached health matters, that's saying that you were not able to come to the hearing, the doctors who consulted with you were of the opinion that Mr. Duterte was not in a position to come to the hearing physically, but that if he gave a written permission, he would be able to take part via video link. Now, that is with regard to the health matters that you just mentioned. They are very important, especially concerning the matter of age. Now, with regard to the rights of Mr. Duterte, we have before us the registrar's or the registry's report that says that Mr. Duterte has been informed of his rights, including Articles 66 and 67 of the Rome Statute, and that that he is aware of his rights and that he is also aware of the charges against him. We have before us the report of the registry saying that he was also aware of the warrant of arrest in the English language and that he is very well versed in the English language. Once again, you have the possibility of these charges being read in English, which was the case today. I have read to you in the French language the rights that he has, Mr. Duterte, before this court, and I'd like to specify once again that this is an initial hearing. In order for Mr. Duterte to be aware of his rights and the charges against him. And then there will be a full procedure that will unfurl leading up to the confirmation of charges that will enable Mr. Duterte to raise all the matters that you have just raised with regard to the warrant of arrest, with regard to the crimes committed, with regards to the charges and any other matters associated with his arrest and the matters of jurisdiction of the court. You have the opportunity to do this throughout these proceedings leading up to the actual confirmation of charges hearing. Now, counsel, with regard to your request for another hearing to be held next week, well, your initial request, that was, this was not accepted by the court. Now, you have seen the two decisions of the court that have been disclosed to you, and you are aware of the fact that these two decisions were refused. And this is by dint of the fact that this first initial appearance hearing does not need much preparation, as I have said to you on a number of occasions. I am now going to move on to the third stage, which is to set the date for the confirmation of charges hearing. After assessing all factors, including the need for the parties and participants to adequately prepare, as well as Mr. Duterte's rights, including his right to be tried within a reasonable time, the date for the commencement of the confirmation of charges hearing is September the 23rd, 2025. I would add that in accordance with Rule 1217 of the Rules of Procedure and Evidence, this date may be postponed by the Chamber depending on the progress of the proceedings, either on its own motion or at the request of the prosecutor or the defence. Before concluding this hearing, I would like to inform the parties of the next procedural steps. First, I would like to recall that in accordance with Rule 1212B of the Rules of Procedure and Evidence, the Chamber holds status conferences to ensure a small exchange of information under satisfactory conditions. These conferences are organised either ex officio or at the request of the prosecutor or the defence. Secondly, a set of decisions will be taken in a timely manner to ensure that the proceedings progress smoothly and expeditiously. More specifically, I am referring in particular to a decision on the arrangements and procedure for the disclosure of evidence, and a decision setting a timetable for the disclosure of evidence in such a way as to ensure orderly and efficient disclosure between the parties. In this regard, the Chamber orders the prosecutor to begin disclosing today the information on the basis of which the warrant of arrest was issued, and to complete this disclosure no later than within the next 7 days. The Chamber will also issue a decision on the participation of the victims who, according to the statute of the court and to the extent permitted by the Chamber, are authorised to present their views and concerns at this stage of the proceedings. We have come to the end of Mr. Duterte's first appearance hearing. I would like to thank all the participants in this hearing, the interpreters and the stenographers. This concludes today's hearing.
Gintod pilak, inaakit ang iyong mga mata.